about what we had discovered in the Iraq War. The US records of the individual deaths of more than 100,000 100,000 people, including more than 60,000 clear civilians, men, and women and children. At that time, the US Embassy in Switzerland stepped forward, and the US ambassador stepped forward to say that Switzerland should not offer me asylum, that it should not entertain giving me asylum. That was wrong. And subsequently, of course, Ecuador has given me asylum in this embassy, and it hopes, of course, its country as well, which is the only reason why I'm able to speak to you today. Switzerland, for its behalf, has recently done something quite important, which is it has given asylum to Husseinov, an activist in Baku, in Azerbaijan, who has now been trapped in the Swiss embassy in Azerbaijan for more than 6 months. I like to think of this as an interesting mirror case. In fact, the parts of the United States government came out to support that decision, whereas the Swedish government has been completely silent on the matter, and the State Department proper has been completely silent on the matter. So I want to look at how these particular cases are indicative of a broader phenomenon that's been happening in the West very clearly in the last 8 years. But I think the tendencies arise from the fall of the Soviet Union, and that the competition for moral space that existed with the Soviet Union has collapsed, and as a result, we see the tendencies that are inherent in powerful states, principally the United States and its allies, which are always there, but are kept in check only through scrutiny and criticism by other actors imbued with power. Now, the United Nations and the Human Rights Council has a role to play, in perhaps the most important role to play, to fill that vacuum of critique that existed in the Cold War, and to a degree kept the West honest and kept it from a collapse of the standards that it said it held dear, but which we might say were most important to it in order to criticize the Soviet Union in that competition for moral virtue as a state. Okay, first let's review what has happened. The Obama administration, supported by varying degrees by its Western allies, in the last 8 years has prosecuted and investigated more publishers and journalists under the Espionage Act than all previous presidencies combined. In fact, more than twice as many as all the previous presidencies in the United States. That must be seen as not simply a gradual perversion of basic notions of freedom of the press and the rights of human rights defenders in the United States and the West, but rather something that approaches a collapse. I used to say that the West was different to the East and much of the rest of the world in that its methods of societal control were more sophisticated. That in the East, journalists are taken from their homes in the middle of the night, but in the West, homes are taken from journalists in the middle of the day. That the primary mechanism of censorship and control of the press and publishers and dissidents was economic. Through a variety of forms of fiscalization, economic pressure is able to be applied to human rights organizations, to newspapers, to individual journalists, to the publishers of books, that dissuades them from engaging in criticism of policies of war or other parts of what is commonly referred to as the deep state. That, I think, was true for many years, with occasional exceptions. What is novel about our present period is that that subtle form of very effective thought control and censorship has now become so extreme that it is no longer subtle. It's become so extreme that it mirrors the traditional notions of censorship and human rights abuse that the West has always complained about when it wants to criticize the actions of other states. So let's look at it in a concrete manner. Today is the 1,566th day of my detention here in the United Kingdom without charge in any country, at any time. The 1,006th day of my detention in this embassy without charge, surrounded by police and UK intelligence activities, which the UK government has admitted. The police component alone now reaches £10 million, $15 million, approximately £15,000 approximately $15,000 per day spent on surrounding this embassy and trying to observe my visitors and myself. But it's not just me. 1,858 days ago, the United States government started what it called a whole of government investigation into WikiLeaks, the publisher, and its staff, me and our alleged sources. That investigation continues on and has expanded in a number of ways. The departments involved include over a dozen different US agencies publicly declared. The Department of Justice National Security Division, the Department of Justice Criminal Division, the Department of Defense Intelligence Agency, the DIA, the Pentagon, the US Army Counterintelligence Center, the State Department, the White House, the FBI as what has now become the lead on-the-ground investigator in the case. As recently as March the 4th, the United States government admitted that attempt to prosecute WikiLeaks and its staff continues. It admitted it in federal court in Washington, D.C., stating that it is an investigation is led by the Department of Justice, National Security Division, and Criminal Division. In that case, we were demanding information about the illegal acts in this investigation. WikiLeaks has filed a number of criminal cases in Denmark, in Sweden, in Germany, in Iceland, in relation to the criminal conduct of US intelligence agencies supported by SAPO in Sweden and PET in Denmark. In trying to understand the abuses in this investigation, we asked the US federal court system for further information. Now, the US government has resisted that case for years, claiming that to reveal any details at all about lawyers being spied on, about our supporters being spied on, about supportive journalists being spied on, about other aspects of its investigation against us and its attempts to prosecute WikiLeaks and its staff, would compromise that investigation and that attempt to prosecute us, and therefore not a single document can be released. Now, of course, it is an absurdity that every single person who's been swept up that investigation still remains a suspect. It is an absurdity that every piece of evidence or witness statements having been obtained still would materially affect the attempts to prosecute me and other aspects of the organization. And in its judgment, that court gave a reason for its agreement with the US government. And the statement by the court illustrates that while the excesses of the US government in its executive are clear, it is not an excess that can be healed by appeal to the judicial system in those states. And I think that is something that is very important to realize. We often talk about excuses often made for abuses in the West, that an abuse by the executive can be healed or is healed in a short amount of time by appeal to the judiciary and the judicial branch or to the political branch of these states. But when an investigation, an attempt to prosecute and extradite and spy on a publisher goes now for more than 1,858 days, and the editor, myself, of that publisher is detained without charge for 1,566 days, and attempts to find means of opening up that investigation to show its illegality are denied by the courts, we can no longer say that the West can heal itself. It requires other bodies, such as the UN Human Rights Council, to step forward and feel the vacuum that has occurred. In that case, the judge stated that on March the 4th, it was necessary to show, quote, appropriate deference to the executive in matters of national security, unquote. And that is why the judiciary refused to examine any of the documents in the case as to whether they really would affect the course of that investigation, or the matters that revealed abuses in that investigation should be disclosed to the public. So this is an extraordinary statement. The necessity of the judiciary to show appropriate deference to the executive. That shows that there is no longer a separation between the judicial branch of the United States and the executive, when statements like that are coming from the mouths of judges. And it is not something that has arisen just for our case on the 4th of March. Actually, that notion that the judicial branch must give way to the executive whenever the executive claims something is a matter of national security is a development that has been evolving over the last 5 or so years. Okay, other people affected by this phenomenon are Chelsea Manning, an alleged source of WikiLeaks, alleged to have disclosed information, including diplomatic cables, and the video that Balthazar Ghazon mentioned, showing the slaughter of Reuters journalists in Baghdad and more than a dozen Iraqis at the same incident. He has now been detained for 1,760 days. His appeal occurs. His appeal is occurring later this year before the US Army Court of Appeal, but he has been sentenced to 35 years. 35 years on an allegation, and it is the only allegation, that he disclosed information to the press. There is no allegation that he disclosed information to foreign states or to terrorist organizations, or that he acted for personal gain, purely that he disclosed information to WikiLeaks and the rest of the press. Special Rapporteur for Torture, Juan Mendez, in that case, formally found against the United States, and that Private Manning had been subjected to unlawful, cruel and unusual punishment. In order, his lawyer says, to get him to make a confession in order to pursue the prosecution against me. Jeremy Hammond, sentenced to 10 years, now on his 1,112th day of incarceration in the United States. The allegation against him that he disclosed information about a private intelligence contractor, Stratfor, in the United States, to us. And we revealed that that contractor, Stratfor, had been involved in spying on activists involved in the Bhopal disaster in India, and had been engaged in an activity to create an unlawful captured investment fund, bribing people around the world to obtain information, yes, to sell to the US government, but also to inject into their own private commodities fund. Barrett Brown, US journalist, now detained for 921 days, recently sentenced to 6 years in prison. One of the allegations against him, which he was convicted for, was the extraordinary claim that by tweeting a statement made by Fox News against me, that he was threatening the FBI. Barrett Brown was drawing attention to a statement by Fox News asking for my assassination, calling for my assassination. By tweeting that, the FBI said that this was an attempt at assassination against him. I had hoped to go through the rest, but it seems that actually there are so many, it takes quite a long time to get through. But let me just give the names. These are not old cases. These are cases that have been ongoing where the person has been sentenced in the last year or are still proceeding. James Risen was mentioned earlier, New York Times journalist, threatened for years with imprisonment. His alleged source, CIA source, Jeffrey Sterling, is up for 100 years in prison. He's been sentenced on April the 24th. He was convicted on January 26th. Only allegation against him is that he supplied a New York Times reporter with information about the CIA. John Kiriakou, the only person arrested and convicted in relation to CIA torture, the only person in the United States. His role, revealing the torture. Sentenced to 30 months in prison after a case that dragged on for years. Thomas Drake, eventually sentenced to 1 year probation, but forced for 7 years to believe that he was going to be facing decades of incarceration, revealing, it is alleged, information about the National Security Agency, and earlier Edward Snowden. William Binney, similarly in relation to National Security Agency. Aaron Swartz, in the United States, faced 50 years of imprisonment and $1 million of fine. A personal friend of mine, a volunteer for WikiLeaks, who ended up, very sadly, being persecuted literally to death 2 years ago. Glenn Greenwald, known to many of you here as one of the Snowden journalists, now in effective exile in Brazil. Laura Poitras, another Snowden journalist, now in effective exile in Berlin. Our Sarah Harrison, who assisted us with transporting Edward Snowden from Hong Kong into a place of asylum eventually in Russia, which we arranged through legal and diplomatic means. A case where a number of other countries represented here at the UN Human Rights Council also tried to assist, but the intervention of the United States was so aggressive and so abusive that came not to be. And those states include Ecuador, Venezuela, Bolivia, Nicaragua, and political support from Argentina. Now, I think it is important to recognize that these states, in this situation, with the United States threatening people as they attempted to give Edward Snowden assistance, stood up and tried to do that. In the end, the abuses of the United States in taking down President Emo Morales' jet, for example, were so extreme that he could not practically be safely conducted from the airport in Russia to Latin America. And there are many other current examples, although I think it's perhaps wise to give you one related to this body, the United Nations. We revealed information about Secretary Clinton's orders that the United Nations be spied upon, that the Palestinian community be spied upon, that particular NGOs be spied upon, that their DNA be stolen, that their fingerprints be stolen, that their retinal scans be stolen, that their passwords be stolen. But there is another case here in the United Kingdom of something similar. Catherine Gunn, now in effective exile in Turkey, a GCHQ translator, working at the GCHQ at the time when the United States was attempting to embroil the Security Council in authorizing its unlawful war against Iraq. She received, and the GCHQ received, instructions from the United States to spy on all the members, especially the non-permanent members of the Security Council, in an aggressive manner in order to influence them and produce a resolution for the Iraq war. Okay. What a number of these cases have in common is not simply that they are recent or that they are conducted sometimes without any charge, or that there are abuses in the formal process. It is that a technique has been developed in the West of punishment as process. So look at the case of Drake, the NSA whistleblower who went through a 7-year process to be sentenced to 1 year probation on a small charge. So here is a case where the process was clearly the punishment, where the abuse and the general deterrent is pushed into the case before eventual conclusion in a Supreme Court or in a higher court, before a trial. In my case, that's thousands of days now of detention without charge at all, not even having the rights of a defendant in the matter in the United States, not having access to any single document about the investigation of our organization. I think that there needs to be some clear policy designed to prevent this punishment as process that is occurring here. In the countries of the West, through their bureaucratic sophistication, have, in response to extremely good standards set up by the Council of Europe and the UN human rights system, adjusted their legal and administrative processes in order to engage in forms of abuse and to set general deterrents that evade the formalized checks and balances that the United Nations and others have tried to construct over a long period of time. I think this is something that is an increasing tendency, and I'm not sure the exact mechanism that is needed to address it. But when when claims of state secrets are used to knock out nearly all of the CIA torture cases that were brought in the United States, and used in the manner that I described in relation to us to prevent proper accountability proper accountability in the US case, are used by Sweden to construct complete impunity into the renditions with the CIA by Swedish intelligence services against asylees in that country. This is a phenomenon that the rest of the world must step in to stop. Okay, so with that, I want to finish on one last point. If we try and pull back from these individual cases and abuses that I have mentioned, to look at this from a geopolitical perspective, what is happening is not simply an increasing tendency towards authoritarianism in the West. There is a desire and a method being erected for the United States, principally, to engage in an extraterritorial land grab through the abuse of law, where it is attempting to apply its jurisdiction to all countries in the world, to reach into other countries and destroy their sovereignty by demanding that its laws apply to their territory. Now, if you control the laws of a foreign country, if you say that your laws apply to the interior of a foreign country, this is the same as having effective control over the population of a foreign country, which is the same as, in a way, annexing that foreign country. Now, the United States has been doing this in a unilateral manner, where it claims universal jurisdiction in relation to everything that it says has to do with national security, including publishing. Similarly, it has also been involved in entering into often coerced bilateral and multilateral agreements on extradition and the sorts of activities that might be forced to be illegal, for example, in the Trans-Pacific Partnership Agreement. In Alexandria, Virginia, in Washington, D.C., where the grand jury for WikiLeaks is seated, more than 67 other countries are also embroiled in having their nationals being pulled in to that jurisdiction in one way or another. Whether that is, for example, here in the United Kingdom, a man who sold batteries to another state, which was then shipped to Iran, and the United States eventually extraditing that businessman to the United States for what it says was a breach of sanctions in relation to Iran, or whether it is in its media cases, where it has claimed that WikiLeaks, a publisher which is not based in the United States, which is headed by an Australian, myself, which is has its principal staff in Europe, that publisher and all its staff are susceptible to its claims of, and they came out earlier this year, espionage, conspiracy to commit espionage, the Computer Fraud and Abuse Act, which is computer hacking, theft of government secrets, and general conspiracy. This means, because of how media organizations work, that once an allegation is taken against a single journalist for being involved in publishing information about the United States national security, including the CIA, its torture programs, or any other matter that the United States claims has something to do with its national security, that all other persons within that media organizations can be embroiled, all of them, the publishers, the editors, the journalists, because that's how information flows through a media organization. It goes from journalist to journalist, from editor to editor, to the technical people who prepare publications. And that is how it has managed to construct a case against a foreign media organization, how it has embroiled Google and other organizations to provide it with information, is by saying that this conspiracy somehow encapsulates all journalists in a foreign media organization. And that is something which is right now chilling the behavior of journalists across the world. I have seen it. I have spoken to other journalists here in the United Kingdom and other parts of Europe, or in New Zealand and in Australia, who will not publish certain information about the United States because they believe the United States will claim that they are susceptible to its laws. And that is an annexation of the democratic sovereign rights of other countries by the United States through its claim of universal jurisdiction whenever it says that its national security sector